Welcome on behalf of the International Commission of Jurists, Al-Haq, Geneva for Human Rights, and FIAN International, the four organizations that joined together to organize this event. And a special welcome to our guests here in front of the room with me. They have made a very special effort to make all the way, very long hours of travel and discomfort to be with us, to tell us about their cases, to tell us about their experiences, and to allow us to learn with them about the many problems that we face in protecting human rights in the context of the activities of transnational corporations. The subject that congregates us today is the one about access to justice and corporate complicity. In 2008, as you should remember, the Human Rights Council adopted by unanimity the United Nations framework Respect, Protect, Remedy that was proposed by Professor John Ruggie. And 3 years later, he proposed a set of guiding principles that were also adopted unanimously. One of those, of the three pillars that that framework contemplates is the one ensuring access to remedy for all victims or those people affected or harmed by activities of business enterprises. Access to justice is essential part of that access to remedy. Many of the cases that involve negative impacts or harm by activities of transnational corporations on the rights of people involve indirect effects or impacts that we label complicity. It's for that reason that in 2008 also the International Commission of Jurists released a report, the result of several years of work of several experts. Copy of it. There are 3 volumes that you can find outside of the room, conceptualizing the meaning of corporate complicity, in serious human rights violations. We are 5 years later, fundamentally in the same situation as we were 5 years ago. There have been minor changes, documents adopted, declarations adopted, endorsed unanimously, but very little real change on the ground. And the cases that will be presented today are witness of that situation. The 3 cases that we will present today are very representative, illustrative of the bigger picture, but I will not advance any information. I will let the witnesses, the actors of the events to tell you. Before we start, just 2 technical issues. We have translations in Spanish and Arabic. Arabic channel 6, Spanish channel 3, please. I should also tell you that the whole meeting is being taped, recorded by the gentleman here in the middle. So if you have any objections to be recorded or your face be showed later on, please let us know. At the end of the meeting, we will take note and we'll do all our efforts to fade your face some way or not with the technical measures. And also I should say that the tape or any recording will be used for absolutely non-commercial purposes. Finally, I should disclose also that for this meeting, there is no involvement of governmental funding or funding from private corporations. This is for the purposes of disclosure. Please take note of it. Now I will start now. First, introducing Mr. Let me take the name right. Muafak Katif, chairman of the Hisma Village Council in the Jerusalem Governorate, who is a victim and at the same time witness of what's happening in the Palestinian occupied territories as a result of the construction of the wall, the separation wall, the annexation wall by Israel, and the involvement of several transnational corporations in that effort. After Muwafaq Katif, we will have Mr. Peter Kayiira Baleke. I will present him in this time, and then the last interveners will be Humberto Piacuaje and Pablo Fajardo, who come from Ecuador, on my left here. So we'll start with Muwafaq. Please, sir, you have 12 minutes to speak. And later on, I think we will show a video also to explain better the situation. But at the moment, you can make your presentation, sir.
في البداية يعني أحب أن أعطي فكرة عامة عن الوضع بشكل عام، عن الوضع الفلسطيني والمعاناة اللي بيعيشها شعبنا الفلسطيني منذ العام 48 من حيث يعني حصلت النكبة وتشرد مئات آلاف الفلسطينيين، واليوم أعدادهم بالملايين في مختلف أنحاء العالم، واللي جزء كبير منهم اليوم بتعرض إلى هجرة متتالية ومعاكسة كما يحصل في سوريا، متمنين طبعا حل مختلف القضايا الدولية بالطرق السلمية والحفاظ على أرواح وممتلكات البشر. بالنسبة لنا في حزمة هي إحدى ضواحي القدس الشريف، تقع إلى الشمال الشرقي على مسافة أقل من 10 كيلو متر من العاصمة.
Situates not far from Jerusalem. It was
على القدس في كافة مرافق الحياة.
We historically independent on on Jerusalem, independent on Jerusalem. It was
in terms of economy, infrastructure,
اعتماد
in terms of water supply.
It has many. The total income in Hizma was dependent on quarries and pastures and
حيث قامت إسرائيل بوضع حاجز عسكري على
Israel situated a checkpoint at the port of Hizma and started to take our lands and started to build the wall on our lands. This wall was 5 kilometers long, took more than 4,000 dunams of our lands. To explain more, I can say that the wall isolated the village from Jerusalem, which was like which made us lose our
وفقدان تسويق منتجات الثروة الحيوانية
main incomes and sources and
social
وخاصة فئة الشباب من الصلاة في
and stopped all the wall which situated on our lands, didn't let our village to isolated more of us, many of us in our village, away from all around the villages and countries.
We have a family specifically.
Okay.
Where the wall has
we were boxed inside and lost pastures. And we were isolated from other villages around because we were surrounded by this wall. It changed our ways to this villages, and we had to took very long ways to turn around and reach those villages. Today I'm here, and I think there's no in the world which prevent us to use our lands and resources. The Israelis had to build this wall
They had
to
cut down
to
all
cut
the
out
trees.
all the trees, olive trees, which we built,
Destruct
which
many houses and
and destructs our houses.
بين مختلف الأطراف والأطياف السياسية والشعبية.
ما مشكلة, don't panic. Even
In 2006, the
الجدار في أرض زراعية، فكان احتجاج
criminal
we
court international.
ماشي ماشي.
no, they will have more settlements in our lands, and the settlers are more and more took our lands. They forced us to leave our lands, and we were boxed outside Jerusalem. We were away from health resources, hospitals, schools, mosques. At the same time, we are surrounded by this wall, and it has a very bad psychic effect on old people and on children and young people. Some houses cannot see the sun because of this wall. We have many evidence to show. In 2004, we were able to stop a decision of destroying a house to build this wall. For us, we won this battle for a while. I would like to say also that Hazma, my village, is very rich in water, and from 1976 till from 29 till 76 was the main source of water to Jerusalem. Today it is occupied, this resource is occupied by the Israelis, and we are forbidden to use our resource of water, and we can't actually find a solution because it's under
الكريمة.
it's under Israeli occupation today. I would like to say here, instead of you all, we have to take decisions to get our lands back
التي قامت بتنفيذ
and to judge all the countries, all the
Take to court.
شركة ريال الهولندية
all the Tecto Code that situate that
السنين
contributed in destroying our houses and resources.
Let me, in the meantime, let me pass to the next case, and then we will have more time to discuss the details of each later on. Peter Kayiira is representative of the Mubende community in Uganda. He's a teacher, a school teacher, and one of the persons who's been very active from the very beginning in fighting against the occupation, the usurpation of their land by the army first, and then a private company that works in the business of coffee plantation and exporting coffee to one of the main markets, which is Germany. Peter, may I invite you to speak? I think we have a part of your presentation will be a video, and then you will have yes.
Die Soldaten zerstörten meine Bananen und meine Kaffeeplantage. Sie nahmen mir mein ganzes Vieh. Sie zerstörten meine Häuser. Ich habe alles verloren.
Ich dachte zunächst, es sei Krieg. Aber dann hörten wir, dass ein Weißer dort Kaffee anbauen wollte.
Gemeint ist der Kaffeekonzern von Michael R. Neumann in Hamburg. Er ist einer der größten Rohkaffeeimporteure weltweit. Seine Bohnen liefert er an viele namhafte deutsche Kaffeemarken. Fast jeder Kaffeetrinker dürfte wohl schon mal eine Bohne von Neumann genossen haben. Auch in Uganda betreibt der Deutsche eine Plantage. Die Einheimischen hat die Regierung dafür einfach zwangsumgesiedelt.
Dieser Fall der Kaweri Plantage ist einer der ersten gut dokumentierten Fälle von Landgrabbing. Das heißt, multinational aufgestellte Unternehmen und auch Regierungen nehmen Bevölkerung in Entwicklungsländern das Land weg, um für den Export zu produzieren.
Neumann selbst betont, mit der Umsiedlung nichts zu tun zu haben. Wir sind in Mubende im Westen Ugandas. Vor gut 12 Jahren sucht die Neumann Kaffee Gruppe hier Land für eine neue Plantage. Auf dem Grundstück, das die Regierung ihr anbietet, leben allerdings Einheimische. Hans Fessler ist Manager bei Neumann. Er hat die Plantage vor Ort mit aufgebaut. Ein Areal ideal für den Kaffeeanbau.
Wir wussten, dass da Leute drauf sind. Es gibt ein Land Act, ein Landrecht von Uganda, das genau besagt, was zu passieren hat, wenn Leute auf Privatland sind und umgesiedelt werden sollen. Und darauf haben wir bestanden.
Laut Neumann haben höchstens 600 Menschen dort gelebt. Und die seien entschädigt worden. Doch die Betroffenen sprechen von insgesamt 4000 Bewohnern. Denen gehörte das Land zwar nicht, aber sie hätten nach ugandischem Recht einen Entschädigungsanspruch gehabt. Die Organisation FIAN tritt für das Menschenrecht auf Nahrung ein. Sie kennt die Klagen der Vertriebenen.
Bevor die Plantage 2001 angelegt wurde, wurden 2 Monate vorher die Menschen aufgefordert, das Land zu verlassen. Es wurde ihnen Entschädigung zugesagt, Umsiedlung zugesagt. Doch das ist alles nicht eingetreten. Da die Menschen überhaupt nicht wussten, wohin sie gehen sollten, sind sie zu Hause geblieben. Und dann kam die ugandische Armee und hat die Leute gewaltsam vertrieben.
Der Kaffeekonzern Neumann räumt zwar die Vertreibung von 25 Kleinbauern durch die Armee ein, die Betroffenen hätten die Entschädigung und Umsiedlung aber verweigert.
Es waren Soldaten. Sie kamen mit einem Bagger und haben alles damit zerstört. Auch unser Haus haben sie eingerissen, während wir fliehen mussten.
Dieses Foto ihres Hauses ist das einzige, was der Familie geblieben ist. Auch Tumwine war Kleinbauer und musste mit der Familie Platz machen für die neue Plantage. An anderer Stelle sollte es neues Land geben, aber bekommen hat er es offenbar nie.
Wer noch versuchte, Sachen aus seinem Haus zu holen, wurde mit Schlagstöcken verprügelt und musste fliehen. Die Kinder hatten Angst und rannten in alle Richtungen. Dann haben sie meine Bienenstöcke und mein Haus niedergebrannt.
Mehr als 2000 Vertriebene sind vor Gericht gezogen. Gertrud Fall kümmert sich für FIAN schon seit 2003 um den Fall. Die 83-jährige Anna erzählt ihr, sie habe 20 Hektar Land gehabt und 6 Häuser bis zu jenem 18. August 2001, als die Soldaten kamen.
Sie haben den Stall angezündet, in dem meine Ziegen waren. Alle Ziegen sind darin verbrannt. Was für ein Unglück. Ich muss weinen, wenn ich daran denke. Als sie mich vertrieben hatten, musste ich hier unter den Bäumen leben. Ich hatte nichts mehr.
Die Neumann-Manager bestreiten, vorher von dieser gewaltsamen Militäraktion gewusst zu haben und verurteilen sie.
Ich selber kam einige Tage später und habe dann irgendwie bemerkt, was ist auch hier los gewesen. Also es muss sehr harsch gegangen sein, dass wahrscheinlich Druck gemacht und kann ich mir vorstellen, dass die Leute wussten, dass das Druck gemacht wurde, dass es mit dieser Umsiedlung, dieser Kompensation vorangeht. Aber dass quasi die Armee aufmarschieren würde oder sowas angedroht wurde, das hätten wir mit Sicherheit gewusst.
Also keine Ahnung im Voraus von einer bevorstehenden Vertreibung? Der Anwalt der Siedler, den wir in der Hauptstadt Kampala treffen, glaubt den Versicherungen des Kaffeekonzerns nicht. Denn die Manager der Plantage seien bei Treffen dabei gewesen, auf denen es auch um die Vertreibung der Leute ging. Eidesstattliche Erklärungen würden das belegen. Neumann bestreitet das. Der Anwalt erhebt noch weitere schwere Vorwürfe.
Immediately after the official opening, the employees of Kaweri Coffee Plantation started cutting down all the crops, coffee trees, banana plants and everything, in the process of clearing the ground for them to start planting their coffee. That's why they are in court. We sued them because they participated in the actual eviction and destruction of my client's property.
Das Urteil ist vor einigen Tagen gesprochen worden. Die Deutschen, so der Richter, hätten das Land als ehrenhafte Kaufleute nicht übernehmen sollen. Sie waren stille Zuschauer der gewaltsamen Vertreibung. Neumann hält das für ein krasses Fehlurteil und ist in Berufung gegangen. Mit 2500 Hektar ist ihre Kaffeeplantage heute die größte und modernste in Uganda. Man preist sie als Modellfarm in Sachen Nachhaltigkeit. Über 3000 Menschen arbeiten hier in Spitzenzeiten. Aufgebaut wurde sie nur wenige Tage, nachdem die Armee alle Einheimischen, die nicht freiwillig gehen wollten, vertrieben hatte. Auch heute ist man sich keiner Schuld bewusst. Schließlich seien die allermeisten Betroffenen doch entschädigt worden.
Da waren die Unterschriften der Dorfvorsteher drauf, da waren die Unterschriften der beiden Rechtsanwälte drauf, des Verkäufers, des Staates. Also hatten wir keinen Grund und auch haben heute noch keinen Grund daran zu zweifeln.
The agreement that these people signed, they were forced at gunpoint. And that is the problem. Soldiers, there is an assistant RDC who was going around the villages escorted by army soldiers, forcing people to sign that he had been given land elsewhere and that he had been given compensation.
Gemeindevorsteher Patrick Kiambade erinnert sich zwar, dass einige Siedler entschädigt wurden, aber mit bloß 50.000 Schilling, gerade mal 30 Euro.
You cannot give a person who has been having land of 10 acres, has been having a house, he has been having his animals, he has been having what all of that, and you give him 50,000. Although they are saying that these people were not compensated at all.
Nach 11 Jahren haben die Vertriebenen durch das neue Urteil zwar Recht bekommen, sollen Entschädigung erhalten, doch rechtskräftig wird es nicht. Alle Parteien haben Berufung eingelegt.
Sie sollen mir mein Land zurückgeben. Das ist das Einzige, was ich will. Sie sollen mir mein Land zurückgeben und mich für alles entschädigen, was ich erleiden musste. Sie haben mir meinen inneren Frieden genommen. Ich habe keinen Frieden mehr.
Very good, very compelling. Peter, give us your complimentary comments.
Thank you very much. I'm a teacher, and in teaching, we have a saying that a picture speaks 1,000 words. By this video, I think every mind now is set to hear. Actually, we have access to justice and corporate complicity in human rights abuses. This is the real story to capture the theme of our gathering here. This company, the Neumann Kaffee Gruppe, entered into business deal to take over land to establish a coffee plantation you have seen in the video. And this is a very large coffee plantation which measures 11.6 square miles. And the land was taken militarily. So after the company had agreed with the government, then the company paid the money, to the government, and then the government deployed the army to evict us. The eviction was actually very brutal because the army was shooting. However, they did not kill, but they were shooting live ammunition to frighten us from our land. However, there were some meetings where we were being sweet-talked, actually, to quit this land. But then we were all very conversant with the laws of the country. This was not provided for under the laws of Uganda. Then we decided to at least hire a lawyer to advise government to spare us, not to evict us. But the government went ahead and evicted us on 18th of August, military day. You have seen the destruction that was made. It was terrible. However, we decided to organize ourselves, and I led the group. We could not actually retaliate with force, but we took a legal action. Before we took this, the government had known, because we had hired a lawyer, that we are going to go to court. And they warned us that it would even be a wastage of time going to court, because the government would control the court and they would delay the case for a good 30 years. Well, by the time the case maybe would have to get completed, many of us would have died off, and maybe our children would be so weak not to carry on the case, and then the case would die a natural death. But I insisted that we would file the case, and we managed to. And the case has been delayed for the last 10 or more years. Finally, going all through that, I'm only happy to share with you that there is now some little success that is coming out of the judicial system of the country. We have gone 10 years, 7 years, and 13 days to reach this small success. It was on the 28th of March when finally a judgment was declared by the High Court judge in our favor. The company has to pay for all the damages, and again our statutory rights of tenure have been ordered to be returned to this title. So we are going to have the damages paid and then our rights of tenure restored. So this has to open another dialogue. If the company wants to remain in control of our statutory rights of tenure, then they have to open another dialogue where they are going to pay for the rent of each year harvested. If not that, we shall go back to physically occupy this land. However, these companies are a little bit complacent, I would say, because normally it is their right. After a judgment like this one we got, they have the right to appeal. But instead of exercising their right to appeal, they went to the papers attacking the judge who delivered the judgment, which is illegal and complacent of them. However, they have threatened to appeal. It's their right. But I think I must tell you that we are even more ready to defeat them for the second time. This time we are not going to defeat them, but we are going to humiliate them, because we have even more evidence to produce at court that we did not have before. So we are just now preparing for that. The appeals do not take so long. They would take long where the judges are not enough, because these courts, the Court of Appeal and the Supreme Court, usually require a good number of judges to be present at a hearing. But of recent, all these courts have been their judges appointed. So I think the hearing will be very soon disposed of, maybe for another 2 years. But I know finally we shall have success. Just one point to note, is that these corporations are a little bit, they a little bit think that they are just helpers. Mainly, there is a thinking that the global north is just assisting the global south to develop. That whatever decision that has been taken in the global north, we should only embrace it as a chance to develop. And that thinking I cannot buy. And we should change from that kind of thinking. Development cannot be forced. It is very easy to force a horse to a stream, but it is difficult to force it to drink. Thank you.
Thank you very much, Peter, and also very, very compelling case. You persisted despite of the many discouragements to pursue your court case, no, to seek justice in court. You persisted, but you will tell us later, perhaps, that you also try one of these non-judicial mechanisms that are receive so much publicity these days, the OECD National Contact Point in Germany. You didn't succeed, but we will leave that for later. Let me now pass to the third case on my left here, the case of the community of Lago Agrio in Ecuador versus the giant mix Texaco and Chevron. On my far left, Mr. Humberto Piacuaje is the leader of the Secoya Nation in Ecuador. He's the official spokesperson for the Secoya Indigenous Organization of Ecuador and the representative of the community in the case against Chevron Texaco. Mr. Piacuaje is the subcoordinator for the Assembly of Delegates of communities affected by Texaco, which includes 5 indigenous peoples, the Cofan, Siona, Secoya, Waroani, and Quichua, and approximately 30,000 people. Mr. Pablo Fajardo here on my close left, he's a lawyer, born in Ecuador, has pursued studies in law at the postgraduate level, and because of his tireless work on behalf of the environment, greater respect for human rights and justice, the chain CNN recognized him in 2007 as a World Hero Defender of Justice. In April 2008, he was awarded the Goldman Environmental Prize, which is considered the Nobel Prize of Environmental Protection. So I'll give you the floor now, sir. Please, I know 12 minutes is a very tight, es muy reducido 12 minutos. Yo sé que no van a poder comprimir toda la experiencia y todo lo que ustedes quisieran compartir.
So 12 minutes is not that much. We realize that you have a lot to say, but it's a start for us to start a discussion. So please take it easy and let's go forward. And will you start first of all with a video? No, the video will be afterwards. So please go ahead, Humberto. Thank you very much. I am Secoya. I was born in the Amazon jungle, and today I represent 30,000 people affected against Siona, Siecopine, Cofanes, Waurani, and Quichu communities, as well as farming communities. I am here representing these groups so that I would like you to have a glimpse of the struggle of 20 years. But you can imagine that I will not be able to tell you much about a struggle of 20 years in only 12 minutes. I would like to tell you how I feel as a person from this culture, someone who was born from nature, and mostly I'm a person who, as a young man, I started appreciating the real beauty of nature, and to grow up as a man harmoniously with nature I was able to bathe in purest waters. I was able to breathe pure air. I was able to admire animals at all times. I was able to look at fish. I was able to enjoy our culture, fishing with respect, hunting with respect of animals. All of these things, I'm sorry, it's a very emotional subject for me. These are moments of life who are profoundly harmonious. And today, Chevron, who formerly known as Texaco, has destroyed everything and has destroyed, first of all, our livelihood, our lives. We have lost ourselves. We have lost ourselves as human beings. We whose knowledge was in harmony with nature and was respecting nature. Our grandfathers who have always told us that we needed to respect nature. And they told us that we always needed to respect nature, and it is what we always did when living in nature, loving nature, living nature, and living in the middle of this wonderful paradise, this wonderful nature that we were living in. But what happened afterwards when in 1964, during the 30 years of exploitation, within that time, I remember how, without truly having knowledge of it, we weren't realizing what was happening to our lakes. They were dropping fuel in it, gas, but we didn't know what it was. We weren't aware. We didn't have. Many people thought, or our grandfathers thought, that this pollution was something that perhaps was healing nature. We thought that it was something that would eliminate some of the ants or beetles that were affecting us. And they were putting all their efforts in trying to live with the terrible smell that all these extractions were throwing. And I also remembered that my mother had collected in a pan on the way we needed it in the jungle. They were trying to use for a lamp, and they were putting this oil, and they would put fabric, and we would do fire, and we would have light. And so there was something initially which we thought was part of nature that would actually serve us. But all this ignorance that we were experiencing, we were not informed. We didn't know what the future would be. We didn't know how the future would affect us, and we didn't know we would have to deal with disease and destruction. We are realizing this just now. I remember that when my grandfather one day at 7 p.m. went to the lake, to the river, thinking that it was clean water, and he came out of the water with his hair full of oil. And when he arrived, and when he came to our hut, my grandmother looked at him, and it was petrol, it was gas, and his face and his hair was all darkened by the oil. And truly we realized on the next day, and we saw that the fish in our rivers were not moving the way they usually did. And afterwards, my grandfather died of cancer to the stomach, and a lot of my family, there were 6 people in my family, my niece, my cousins, young people, all of them died of cancer, uterine cancer, stomach cancer, lung cancer. All of them were affected by cancer, and they all died of cancer, and many of them died, but because we didn't even have enough money to take them to a hospital. So we weren't even sure of what many of the people were dying. Some people were dying of diseases that seemed to be cancer without us having true knowledge of it. And these populations are about to disappear. Our people are disappearing. And I think that these companies have to recognize the human damage. They have to protect and act while thinking of the life of future generations. And this is our struggle. This is the struggle that we want to bring to you, that we would like to tell you about, of 20 years of struggle for life, for dignity of our children. We are losing this struggle, and the companies need to gain awareness. They need to, most of all, start thinking properly that once they have destroyed the lands, there is no moving forward. But truly, Chevron and Texaco do not wish to recognize the damage that they have caused to indigenous and rural communities and farming communities. Because of the disasters that happened, for these damage that was created, mostly to our cultures, to our culture, the nature itself, we have created a union of people, of men and women affected by Texaco Chevron companies. And our only objective is to obtain and struggle until the end in order to get the remedies, to get the money that they owe us. What Chevron is doing, what they are saying, the obstacles they're laying ahead of us for all these times. Chevron, with all its wealth, is confronting us. All the wealth that it gained out of our territories is fighting us in every way it can. But we are only trying to defend a dignified life, to defend nature, defend our lives and that of our children. And for these reasons, we have lawyers. There are many people fighting on our sides. And these people are trying to unite the struggle. And I think that the time has come to analyze these issues. And when we bring these debates and analysis to these places, we must stay and agree that Chevron is trying to raise obstacles and traps in every way it can with all of its resources and its economical power. They're fighting us. We do not have that power or these economical resources, but we profoundly believe that by raising these issues in front of you, perhaps together we can find some legal element which perhaps will lead us towards dignity. And we hope that this whole struggle will end with justice for the people affected. Thank you very much. Well, thank you very much, and thank you to the Commission. Thank you to the Commission who is giving us the space in which to speak. So first of all, we're going to show you some images so you can have an idea of the damages done by Chevron. In numbers, what Umberto has said, there are thousands of pods like the one on the image here. There are 60 million liters toxic water which has been thrown into the environment. And there are thousands and thousands of oil which has been dispersed in the environment. There are 880 pods, toxic pods such as this one, which are also creating major environmental problems in the Amazon forest. And it's 5 million acres which have been destroyed. This environmental damage has created a major impact on health. There is more than one case of cancer per family in the Amazon forest. Children born with congenital diseases, and there are 2 indigenous communities which were completely destroyed, disappeared entirely. And for this reason, we have started this trial over 20 years ago. In 1993, we started this trial. And when we started in New York. Because what happened is Chevron wanted the case to be brought to Ecuadorian courts, and they were saying that it was a problem of Ecuador which should be solved in Ecuador. And they also started working with Ecuadorian lawyers, saying that this is where the trial should take place. And the court in New York in 2003 sent the case to Ecuador. And in 2002, they sent the case to Ecuador. And in 2003, we started fighting in Ecuador. And Chevron actually signed a commitment saying that they would respect whatever decision would be taken in the Ecuadorian court. But what happened afterwards, we had many, many problems which were accumulated. There are about 215,000 sheets of papers who constitute our file. In 2011, first Chevron was condemned to paying 19,000 million for their environmental crimes. And today, although the sentences have fallen, Chevron does not want to pay. Chevron is again trying to call on justice, and they've done a number of things. They're trying to fight. Chevron say they will fight until hell is frozen, and then they will start skating on hell. There is in no part of the world is Chevron winning. This is what their lawyers are saying. So this will be a message from Silvia Garrigo, who is the Chevron speaker. They're saying, where do you want the judge to be? Where do you want the trial to take place? And Chevron is responding, there is no court in the world which can judge us. They're saying that they want impunity forever for their crimes committed in Ecuador. With all of these elements, Chevron today is trying to bring forward a number of judicial events. There are at least 20 trials going on in the United States. And they're saying that in the Supreme Court of the United States is authorizing us to bring a sentence in whatever part of the world we see fit. But Chevron is raising major campaigns against the Ecuadorian state. They're actually suing the Ecuadorian state. They have spent more than $60 million in lobbying so that Ecuador may be punished because they're trying to act against Chevron. They're doing a media campaign to attack the Ecuadorian judicial system. And on top of it, Chevron has also contacted at least 2,000 lawyers in a number of countries so that they may all attack us. We lawyers, we indigenous people, we farmers, so that we may back off. And also in the United States, they contracted over 100 spies in a number of countries so that they could spy on what we were doing and try to defeat us. And they also called on experts who currently work for Chevron. They have infiltrated the government. They're trying to they have converted some of their activities in Argentine. They're trying to make bilateral agreements, commercial agreements, asking Argentine to support Chevron. There are acts of corruption which have been proven, and the way they're trying to fight justice, they're doing it with more crimes to fight against their responsibility for the crimes committed in the Amazon forest. They're committing yet more crimes. We, Umberto, me, and the people we represent, we will not stop. We will not be shamed. We will not be scared. We will continue, and we will continue fighting until Chevron pays for the crimes committed in the Amazonian forest. What we ask to the United Nations Human Rights Council, we want them to defend the rights of indigenous communities. There is a working group on multinationals' responsibilities. We want their responsibilities to be, we want the international companies, multinational companies, to respect national laws in country and to respect environmental laws. We want to reach justice. This is our dream, and this is why we will struggle until the end.
Hello, Humberto, a very moving testimony. And now that you make a call to the United Nations Human Rights Council, to its many subsidiary bodies, special rapporteurs, working groups, etc., which they should take action indeed in this case, which has been under the radar for quite a long time. This reminds me also that in March this year, the Human Rights Council adopted a resolution on the issue of the settlements in Palestine, whereby the Human Rights Council called on the Working Group on Business and Human Rights, 5 experts from 5 different regions of the world, to pay attention to the situation in Palestine and to the involvement of private companies in the international crimes that are occurring there. A question that everybody has still in its mind is has the working group taken any action since then? Does it intend to have any action? We hope to receive an answer to that question soon, we hope. In the meantime, may I invite you to provide comments and formulate questions, please, to our panelists. I'm gonna give the floor first in case if there is any representative of any of the concerned companies here. So because there are several important charges that are being leveled against them here, maybe they have the right to defend themselves. Is anybody here from Chevron or from Neumann Coffee or from Raywell? Sir, in the back, please introduce yourself. You have 3 minutes.
Thank you. My name is Jasper Wouters. I work for a law firm here in Geneva, King & Spalding, which represents Chevron in the investment arbitration case. And I first say, actually, I was hesitating whether to take the floor because I'm very much humbled by the personal story of Humberto Piavache. Clearly, there is human suffering involved here. And the question, I think, for the group and for discussion, as we talk about complicity of companies in the context of human rights abuses, is whether we're, first of all, looking at the right culprit. So the examples of Uganda and the wall in Israel are examples of where there seems to be complicity between a particular company and the state. In this particular case of the Chevron Ecuador situation, one possible culprit linked to the state, very much involved in petroleum activity in the region, is not being examined and has been deliberately left aside, preferring instead to go after the big multinational. Now, personally, I'm not involved in the details of the case at all. I work on completely different issues. But I am aware of the fact that in this particular case, it's not simply a fact of David versus Goliath, but it's a question, is it the right Goliath that is being challenged? Secondly, and one cannot deny the fact that there are a number of concerns that have been raised about the means by which this fight is being fought. Justified as it may be, perhaps. But there are very serious accusations and evidence in respect of fraud, fraudulent evidence, corruption of experts, corruption of judges. Unfortunately, that is part of the story that has to be told in respect of this case. Very much unfortunate as it may be, any fight, even a fight between David and Goliath, has to be a fair fight based on the basis of respect for principles of law. And it's very much with that background in mind that Chevron started this investment arbitration case, alleging that perhaps justice was not done in Ecuador. And in response to the investment arbitration case, 4 times this very well-respected arbitral tribunal, including an arbitrator appointed by the government of Ecuador, has ordered Ecuador to wait, not to enforce this judgment until the merits of the case, including allegations of corruption and fraud, have been examined. And when we talk about a number of US court cases, one cannot deny the fact that over a dozen of US courts have found there to be obvious fraud in the context of the dispute that is being was conducted in Ecuador, and has ordered the disclosure of a number of documents no longer protected by attorney-client privilege. There are serious concerns here that are raised and that Chevron feels legitimately can be raised in the context, for example, of an investment arbitration, where both sides, Ecuador and Chevron, have appointed an arbitrator and there's an independent third arbitrator. In the context of this investment arbitration, our firm, which represents Chevron, believes that justice must be done in all respects, and that includes respect for international law, such as international investment law. Thank you.
Thank you, sir. Is there any other company that would like, it has a representative here and would like to speak and to present its own views? Or any of the concerned governments, perhaps, the government of Germany, Ecuador, or United States on Israel? Or the ambassador from Ecuador, please.
Thank you very much, Carlos. I'm very sorry that I'm late for this meeting. I had to chair the task force on human rights and disability as member of the vice chair of the Human Rights Council. But I grasped what our friend, the lawyer, just said a few minutes ago, and I would just like to state that undoubtedly what happens in the case of Chevron is a long issue of more than 20 years in which the indigenous communities of Ecuador, I think you just touched the light. I'm familiar with this room because this is where we meet for gulak in the morning. But the actual case is that it has not only the component of the indigenous having taken Chevron to trial in New York in the 90s, and then the decision of a New York court to take it to Ecuador and the compliance of this, and then the use of the bilateral investment treaty. The bilateral investment treaty was signed between the United States and Ecuador, and it became effective in 1997. Chevron, then Texaco, had left Ecuador in 92. We believe that it was not applicable. We stated that, but the arbitration tribunal fundamentally asked Ecuador not to execute a sentence of its tribunal. We find that very particular. We have internal laws. We as a member of the government do not have the capability of standing and suspending a sentence from one of our tribunals. This is still under argumentation, and I do believe that there is a case that is in The Hague where this is, but there are many other cases in New York which I undoubtedly am not familiar with, and I cannot respond to this. But this is an issue of this was a private issue between the indigenous communities and Chevron. And now Chevron has taken the government of Ecuador to trial in a strategy and in a public strategy also to affect its prestige and its international standing with the courts, and that I find unacceptable. I do believe that whatever presence Mr. Fajardo has in this meeting convoked by NGOs is as representative of a community. I walked in to hear what the lawyer said, and I find it appropriate that I should be answering this, but this is for me an issue of information by Mr. Fajardo, who I respect very much, but he is an individual, and his community have an issue of environmental depredation by a company. It's still under judicial branches in many courts. Chevron has taken us to many places, and we are a small country that is under a lot of, let me say, a lot under somewhat stress in extended ways into dealing with so many cases that Chevron has taken to us. Let me only say on an issue on a personal basis, I wrote my thesis, a doctoral thesis on transnational corporations and law in 1975, probably when most of you were not born, having seen so many faces, young faces here. But I never thought I would confront, as ambassador in the United States, a transnational with all its capabilities. It's a daunting task. It's like a man standing in front of a tsunami. And so I do think that in the new realm of human rights and law, transnational corporations and human rights are a new frontier. I do think that we will be looking in the realm of new jurisprudence in academia, of looking at the respect for human rights by enterprises that have multilateral capabilities way beyond the capabilities of a country. That is the future, and I just wanted to intervene to say a word about my country and to put the things in perspective, in the Ecuadorian perspective. Thank you very much.
Thank you, Ambassador. Any other government representative who would like to, the concerned government, of course. If no, please, participants, ladies, gentlemen, you are invited to intervene, to formulate questions, comments to any of the three groups here represented. Introduce yourself, please, and formulate your question succinctly and directly, please. Is any questions there? Please don't feel intimidated. Perhaps you have received a bit of a scare shot here by this sort of adversarial exchange, but since this is a very informal meeting, no official, so please feel free also to come out with your own shots. Yes, please.
Thank you very much. My name is Victor Hugo Rico. I'm from the Center for Human Rights and Environment, but currently working at the ILO. I would like to make a remark and then a question to Peter. The remark is I do also believe that it's important to respect international law, but in the case of investment law and human rights law, there should be a clear supremacy on the obligations that derive from international human rights commitments. And therefore, I would strongly suggest that if there is a commitment in the case of the private company, Chevron, to respect the decision of the rulings of the Ecuadorian courts, it should also be consistent with that position. Having said that, I would like to ask you, Peter, if the appeal, what is the consequence of the appeal? It suspends the execution of the court ruling, and if that is the case, how are you going to proceed in order to try to fasten as fast as possible this procedure instead of waiting 2 more years in order to be able to get the redress and the land back? Thank you.
Let's take 2 other questions just to put them together and then answer. Yes.
Thank you very much. I'm with the UK mission. I couldn't find a flag. I'm just interested to know if any, what the awareness is on non-judicial grievance mechanisms, any remedy in a non-judicial capacity, if any of that's been explored in any of the cases that we heard today, and what their view is on that route, please. Thank you.
Yeah, thank you very much. I'm from Namibia. I have different heads, and I would like to just ask some pertinent questions towards this issue. One thing is really if the Commission is going to take up this issue, maybe for someone to study the judgments and then lift out the questions and issues that are of general application, so that actually a template is made as to how to deal with this kind of cases in future. Because I know because I'm not familiar with the case, but I'm a lawyer by training and practice, actually. And I'm the Deputy Minister that side of Justice. and I do come across these kind of cases time and again. For the most part, I understand very much the tactics that the lawyers are playing there to delay, actually, and to avoid a precedent. Because that is thinly veiled for even anyone who is not familiar with that case. And but there are fundamental issues that here should be examined. One thing that our colleagues, especially from the developed countries, that teach us is actually the independence of the judiciary. And when it comes to the independence of the judiciary, everyone is looking at government as the usual culprits. But there are some jurisdictions where independence is defined. Independent from who? And sometimes the poor politician does not have even means to influence the judiciary. But there are those that have means to influence the judiciary. I don't need to mention names. But if you examine this kind of issues, then you would know immediately. And the question now comes, the independence of the judiciary has to be examined. Who actually supervises the judiciary so that they are able to detect from what avenues and stream can undue influence come in? And as far as the judiciary is concerned, I'm a politician at the same time, and we politicians are required to declare our interests. I don't know of any judges that declare interest. Maybe in sub-jurisdiction, these things are there. But so there are many, so these are actually good cases to study and then to lift out general principles of application so that you actually prevent and are better armed in order to protect people like the affected who made these cases. These are my only comments that I would like to make. Thanks.
Thank you, sir. I invite Peter, please, to respond.
Thank you, sir. I think there was a very important question about the judgment and the appeal. What is the consequence of the appeal? Normally, if you want to appeal and your appeal has been allowed by the court of, we started with the High Court. Now the appeal is going to be lodged to the Court of Appeal. Normally, if the appeal has been allowed, there will be a stay of the judgment, a stay of execution of the judgment. But the judge was very careful in making the decision because he also knew of those delaying tactics. And this case has been delayed for a good 10 years. And the judge did not want the remedy to delay for another 10 years. So he automatically knew that the company would be adamant and they would prefer an appeal. So he put some kind of a barrier to the appeal. And if they appeal, it could be even another way of helping us, the victims, to get the redress very soon. Because according to the grounds, and if you look at the examination of the judge and the evidence that was produced, the appeal is just intended for delaying the remedies. So he ordered that if there is any one of the parties who wants to appeal against the judgment, they must put the decretal sum, pay it to the High Court, such that the High Court keeps the decretal sum, which is 37 Uganda billion shillings, around something like $14 million. They place it to the High Court. So if they win the appeal, they will get back their money. If they lose the appeal, then the victims will not bother going back to demand these remedies from anyone. They will go just straight to the High Court and get their remedies. That was the reasoning behind it. So now they are fidgeting to appeal, but this is a very big barrier towards them and their business. But now they have made an application for the stay of the judgment again in the Court of Appeal, that they were given a very big barrier which deters them from exercising their right of appeal. They have forgotten one thing. When we took them to court, the company made an application to the High Court that we, the people who had taken the company to court, we were too poor to pay their damages, the costs after they had win the case. They said they had a very fertile ground to win the case. Therefore, they asked the High Court to order us to pay 20 million shillings for their costs. Failure to do that, our case would stand dismissed. It was a technical part, but actually, we were ordered to pay this money in 30 days only. Failure to pay the money in 30 days, our case against the company would stand dismissed. We are fortunate that we raised this money, being helped by an NGO, Action Aid International, Uganda. They helped us raise this money, 20 million shillings, and we deposited it with the High Court. So, this is the precedent that has been set within the same case. Now they are fidgeting to avoid paying this $14 million. But this application is yet to be disposed of. A hearing is going to take place very soon. They appealed and they made an application for the stay of the judgment. So if it is honored, their appeal is honored, we shall go, because during the process of the case, I have been doing a very serious research. And of recent, the company was maybe, it is by luck of God. This company made a resurvey of the land they occupy. Fortunately, when they made the survey report, they put some very important information, which I have always liked them to disclose. Now, this report, the survey report, it was issued this February this year. It contains very good information for us to defeat them. Not only defeating them, but we are going to legally humiliate them.
The NCP, the non-judicial mechanisms here, the gentleman asked you about the non-judicial mechanism, NCP.
Oh, yes. There are some extrajudicial mechanisms which are put in place. We also tried to exploit this. During our struggle, we have been working with humanitarian NGOs. One of them is FIAN. Again, they are the organizers, part of the organizers of this occasion. We started working with FIAN in 2003. Up to now, we are moving together. Now, FIAN helps us to spearhead an international campaign. Here in Europe, this case is well known and well published. Journalists also know, and they have been following, and they're reporting frequently about this case. Now, FIAN in 2009 helped us to file a complaint at the OECD National Contact Point in Germany. Sincerely, the company was summoned to appear before the NCP. They said they were not going to come. They deliberately. But then the NCP tried to convince them, and on one occasion, we met. We made a few deliberations. But then there was one thing which I want to comment, and I have always commented, that this OECD National Contact Point of Germany, I don't know other countries, but of Germany, is a little bit misplaced. Why? It works under the Ministry of Economics and Technology, which Ministry of Economics is also responsible of promoting investments abroad. It's its sole responsibility. Now, the NCP is also charged with the duty to see the compliance of these companies abroad with the OECD guidelines. And the minister is superior to the OECD. So it is an interest a conflict of interest between the OECD and the minister. And the minister is powerful, more powerful than the commissioner, you see. So actually all the efforts of the OECD were suppressed, and actually the hearing had to be taken over by the Minister of State. And this investigation was ended abruptly but in a futile manner, whereby the OECD cleared the company of all the charges we had laid. One of the charges was a simple one, because we called upon the NCP to call the company to allow or to accept to sit on a table with us to have the matter resolved amicably without going to court. So even this, the OECD could not do, and they said, no, the company is very clean. You have empty claims against the company. Now those empty claims are the ones which have made us get this judgment. I want the NCP or the government of Germany to go to Uganda and tell them you have empty claims again.
But very interesting indeed, sir. Very interesting. The point is, if I may comment on that, is that NCP national contact points of the OECD, they claim to be not a judicial or a remedy process, but a mediation mechanism. No? But even that, in this case, it doesn't seem they have fulfilled that claim, no? that task, because they didn't want to mediate and sit you around the table with the company. So very interesting. So that perhaps will help us here in the United Nations, in the Council, to better understand these mechanisms and see the real potential beyond talking. No? I want to ask perhaps a little bit more from Makwa, Elish, perhaps you of Al-Haq, the sponsoring organization. If you can talk a little bit more about the case that was dismissed in the Netherlands. No, there was the prosecutor doing investigations against the company involving in lending and renting cranes and equipment in East Jerusalem. Could you tell us a bit more, please?
Sorry, can everybody hear me? So my name is Eilish Nikhania, and I work for Al-Haq, which is a Palestinian human rights organization, the oldest human rights organization in the Middle East, in fact. And Al-Haq in 2010 brought a case against the Dutch company Rual, which is a company that provides cranes, rents cranes and that sort of equipment to construction companies. They rented those cranes to those who were building the annexation wall that Maofak spoke about. And Maofak has given us a good understanding of the effects of the annexation wall in not only destroying property, extensive destruction of property, and not only removing the potential for livelihoods through the destruction of olive groves and so on, but also the land grabbing, the appropriation of land that must happen in order for that annexation wall to be built. In 2006, between 2006 and 2009, the cranes that Rual rented to Israeli construction companies were spotted 3 times, twice building the annexation wall, or helping to build it, and once building an industrial zone in one of Israel's illegal settlements in the West Bank. The first time that it was spotted by a Dutch news company, in fact a news camera crew, so it was broadcast on Dutch television. And Dutch civil society, who were interested in the issue of Israel-Palestine, mobilized and engaged Al-Haq, as did the community of Hizma, Al-Khatib, and a couple of Al-Khadr, and a couple of others who were affected by the wall. So Al-Haq took a criminal case against Rual for complicity in war crimes and crimes against humanity. The case lasted 4 years, and unfortunately, just the middle of May, the Dutch prosecutor dismissed the case. The Dutch prosecutor, there were a number of obstacles. One of the main obstacles was the difficulty in gathering evidence in a case like this. In these extrajudicial cases, it's always one of the difficulties cited almost. Another difficulty was that the prosecutor decided to weigh the case against the entire settlement enterprise of Israel rather than the effects just on these particular villages, and therefore set the bar so high that it was almost impossible. This is particularly difficult for small organizations like Al-Haq. We have Peter talking about the difficulties in raising funds for this kind of exercise. If we are to access legal remedy at an international level, it's very difficult to legitimize or validate or justify doing so on some occasions if the reality is that the bars are set so high that we are bound to lose. So the positives that come out of it, I suppose, are, for example, not only were some senior people in the Ruel company, not only were their offices raided by the prosecutor, but actually their homes. I don't say this in some sort of a personal glee, clearly, but that it's a very clear message that can be sent to those involved in these companies who are aware of the effects of their behavior, let's face it. And so we can find a positive in that. Obviously, the level of publicity that was also gained from taking the case was incredibly important. But I guess I would like to ask Moafak, perhaps, if he wouldn't mind, to give us an idea. Of course, you please speak about whatever you like, Moafak, but to give us an idea of perhaps the frustration of going through all of the efforts of collecting testimonies and affidavits from your village, only to realize that the Dutch prosecutor was going to dismiss the case. Is that okay?
شكرا للسؤال.
Thank you for your question.
آلاف مواطن يعني الكل في مجموعة يعني الأشخاص وكل الأهالي في حزمة المالكين للأراضي. في هذا الموضوع حزمة خسرت 4318 دنم من الأراضي، وكان طول الجدار 5 كيلومتر.
Even the impacts of all the Israeli measures cannot be summarized. Most of the land was destroyed, all the trees and the plantations were
الجدار والاستيطان. جدا أيضا أن نعلم.
It's very important to note that Hizma is circled by colonies from all around, so all of Hizma. Even while we are asking for our rights, through the Israeli judicial system, we were only able to get a judicial court order to destroy one colony of all these colonies in 2011. It was not executed until now, a decision that was not executed. Another repercussion is the inability for families, individuals in the same family, to communicate because of the wall passing through their houses and lands. I don't think that any of you would ever be able to live far away from a family member, whether a mother, a father, or children. And I assure to you in this meeting that coming to meet with you from Palestine today was much easier from passing or cutting at 20 meters from one point to another in Hizma itself. So it was much easier coming to you all the way from Palestine than to actually go and visit a neighbor 20 meters away in my village. And in the Human Rights Council, we demand to help the citizens to be able to profit from and make use of his land the way he sees just. The world today is suffering from incredible economic crisis, suffocating. But do you think we're allowed to even open a simple project at any level? A month ago, one of the connecting lands to one of the plantations or agricultural lands was completely destroyed. Not allowing us to use the land or communicate between point A and B. And this is just a small example of our sufferance on day-to-day levels. Building more colonies has to stop. Clifflands have to, destroying clifflands have to stop. Destroying houses, individual houses, any potential project, ranches, animals, or any other Palestinian scenery has to you have to help us stop destroying any Palestinian scenery or any form of living. And I'd like to thank Al-Haq Association of their complete total cooperation and their articulation and judicial demands to asking for our rights to be returned. Thank you very much, Mr. President, and thank you, ladies and gentlemen.
I think we have a very, only 15 minutes to go. May I invite you for a second round of questions or comments, please, and then we will wrap up here with our friends from Ecuador. Is any question, comment from the floor? No, you are all convinced or totally? Okay, yes, yeah. Could you use the micro, please? Just sit there. By the way, you had plenty of other chairs, but you can use that one. Please, you can use that one.
Sarah Joseph, I'm from the Caston Centre for Human Rights.
Hello, Professor.
Oh, thank you. I think it's also curious, and I think the ambassador might have alluded to this, that Chevron is asking for the government of Ecuador to now interfere to stop the enforcement of a judgment which is problematic for separation of powers, for the executive to be telling the courts how to enforce its judgment. I also have a question for Pablo Fajardo about the actual case. The $19 billion, my understanding is that $9 billion was contingent upon some sort of apology. If Chevron had apologised for its behaviour in the case. And it now seems the time has passed for the apology, and therefore they have to pay the $9 billion. My question would be that one would think that $9 billion should at least be also contingent upon appeals within Ecuador, that Chevron should have a right to appeal, and then at the end of those appeals, maybe this apology thing comes into play. That's all.
Thank you. We have a follow-up question there from our friend.
Just one suggestion to Peter, sorry, again. I was wondering, because with this UN business and human rights frame, the non-judicial mechanisms, it's promoted. They are promoted to be used in order to try to conciliate different case-related issues and matters with multinational corporations. And you have shown us that the German national contact point was totally weak with regard to the research and outreach possibilities in order to understand the case. And now you have a ruling on your own country that states just the opposite than what the national contact points have said. And what you told us about the conflict of interest, it's barely in most developing countries NCPs. In Latin America, I come from Latin America, the very same department within the Ministry of Finance which promotes international investment is the one who has to monitor multinational corporations' behavior as well. So I was wondering if you have thought in the upcoming OECD meeting, because the investment committee of the OECD has a power over the ruling or the declaration and the determinations of the national contact point, whether to request some clarification on the on this declaration from the German national contact point. So in order also to expose the deficiency or non-efficiency from these non-judicial mechanisms that are so much promoted within the UN human rights standards with regard to the guiding principles. And I would perhaps think that it could be a good wake-up call for the national contact point in order to understand that there should be more responsible research and fact findings in order to come up with declarations that may be so against reality as you have been able to prove in national courts. So have you thought to bring that to the investment committee? And if you have, there are plenty of venues that you can channel that, like there are many instances of multi-stakeholder dialogues within the meetings of the investment committee in late June. Thank you.
Okay, thank you. Let me now pass the floor to Pablo Fajardo, please. Could you respond to the question?
Primero, decir algunas cosas importantes. Que el juicio se tramitó en las Cortes ecuatorianas porque fue Chevron quien escogió las Cortes de Ecuador para litigar. Chevron pidió que el juicio vaya al Ecuador y alabó las Cortes del país. Hoy esa corte que Chevron escogió es la que Chevron la
on the courts of Ecuador, but it is the courts that Chevron asked for that he is now condemning. And on the facts on which that Chevron in contesting were actually generated as flaws were actually generated by Chevron. But if those flaws are so strong, then how can we bring forward? And also the victims do not have money to pay for their attorneys, but Chevron, yes, they do have money. Chevron has wasted more than 1,300 millions to hide the corruption which they have performed. And they are trying and violating the pact which they made initially when asking for Ecuadorian courts. What I would like to say is that if the judge was given a response on the resolution by asking that over $90 million be paid to repair the case, this is not as indemnization for any other people. This is just to pay for the environmental damage that they've actually caused. So what they're asked to pay, but the indigenous people want to be paid damage for the moral damage they have received. And they also want public excuses. And also they could have paid less. The indigenous communities were asking for a minimum amount with public excuses. But because Chevron were not giving public excuses, today they're being asked for double the financial sanction that was initially decided. As far as the scientific proofs that we have in this case, the case is now held in the Court of Justice because we think that in terms of the country's sovereignty, Chevron will have to pay the sanctions the EU asked for. But in terms of the decisions, what does Chevron want to do with the judicial decision that were taken? They want to force the Ecuadorian state to submit to their wish, and they're trying to sue the government so that the government will prevent the plaintiffs from moving ahead with the court. And this is absolutely illegal because in this court case, it is victims, the indigenous communities, against Chevron. The state of Ecuador is not part of this trial. So, but the state, which is receiving money from Chevron, they are extracting 4 judicial points. They're trying to force the Ecuadorian state not to execute the sanction. So there are different sides, because if this arbitrary fact is acted, it will violate the human rights of the indigenous communities who are themselves suing Chevron. So we will not allow for the sentence to be commuted, and we want the sentence to be acted on as per our rights. Because as the judge said, we cannot allow money to have more worth than human rights. What we want is a resolution based on rights and on the law of the Ecuadorian government. And they're now we are also bringing the trial in other countries such as Brazil, Canada, and other countries, because we want other countries to try and implement this sentence. And we are going to go and attack Chevron in 10 more countries because justice has to prevail and no arbitrary decision can defeat us in the court that Chevron has chose, which was Ecuador. Thank you very much, Pablo Fajardo. We see that you seem to be very committed to moving forward and to use the means of justice, of judicial power, due process to obtain true justice. And this, obviously, we think is absolutely correct and fair.
Reaction in 1 minute, if you wouldn't mind.
Thank you very much. And I think I can just, first of all, ask address from you, business card, because I need to exchange with you. This is very important, because if we are to correct any situation, we can correct it from the point of view of a mistake that has been done. And we could avoid mistakes of this nature appearing in the future, such that our generations to come can enjoy a better life. I want to read this paragraph to you, just a simple paragraph from the judgment. The German investors had a duty to ensure that our indigenous people were not exploited. They should have respected the human rights and the values of the people, and as honorable businessmen and investors, they should not have moved into the land unless they had satisfied themselves that the tenants were properly compensated, relocated, and adequate notice was given to them. But instead, They were quiet spectators and watched the drama as cruel and violent and degrading eviction took place through their own workers. They lost all sense of humanity. That's the paragraph. Now, it is just contrary to what the declarations of the NCP in Germany were. So, it could be of interest to this upcoming meeting to present these two views. This is the view of the judge, and this is the view of the NCP. Which one is better regarded by the this OECD arrangement? And if we have to make it out of the context of ensuring some kind of real arbitration, can we have these NCPs removed from the ministries of finance and maybe placed below the ministries of justice? Because according to me, arbitration is a little bit related to justice, although not like that. A tribunal is a quasi-judicial body. Just that relationship brings these NCPs to be placed before or below the ministries of justice. At least there, they can afford better services to the complainants.
Okay. Thank you very much, Peter, Kayiira. Thank you, especially Humberto Piaguaje, sir. Gracias, muchas gracias por venir. Pablo Fajardo, Makwa Katif, Elish, Peter, again, thanks very much appreciated. I think it was very interesting and an amazing account of events and facts, and also a recall of legal principles, about the effectiveness of the judiciary, remedies, the challenges to that come from different corners, not only from lack of means, but also from their own, from the existence of the use of the international legal arbitration, and etc. In response to the question from the gentleman from Namibia, I have to say that the ICJ will write a report of this event and another seminar we had this morning on the same issues, in which we will highlight these questions and try to clarify some principles. We have the issue of access to justice, to judicial means of redress in these cases as a key component of our work in the area of business and human rights. And is, as I said at the beginning and in the middle of my presentations, moderation, it is, of course, a fundamental mission of the ICJ to promote the rule of law and protect human rights through the means of rule of law. And that means essentially an independent judiciary, and the possibility that rights that we all have are protected by the judiciary, by an independent and impartial judiciary. Any act, any strategy, law, that will tamper with that right, with those principles, of course, will meet with our reprobation. So with that, I have to thank you all for your patience, especially at the beginning. We have to solve some technical glitches. Thanks a lot for all the assistance we had, from people of HIAN, assistance in ICJ, in Al-Haq, and Geneva for Human Rights, and encourage you to take all these issues back to the big room, in which, of course, we have difficulties to have access, and these kind of things are hardly ever presented and discussed. Governments themselves, they seem to have reticences and reluctance to sponsor these kind of things. Perhaps for fear of being labeled as taking sides, but I don't know. They prefer to talk about non-judicial means, company grievance mechanisms, and that sort of things. Very welcome, sirs. But of course, here in the Council we are to protect human rights through the rule of law as well. And please pay attention to the work of the judiciary in these cases. Thank you again, and good luck. Thanks.